Okay, picture this. It sounds absolutely wild, right? But this question, which is based on a real event, is pretty much where the modern law of negligence all began. It really forced the courts to ask a massive fundamental question. Who are we actually responsible for in our day-to-day lives?
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome. If you're tackling the SQE1, you already know negligence is a massive topic. And for any negligence claim to even get off the ground, you have to clear the very first hurdle, establishing a duty of care. So let's dive right into this core concept and really break it down step by step. In the landmark 1932 case Donahue v. Stevenson, now where the claimant got really sick, the court came up with the famous neighbor principle, which basically says you have to take reasonable care to avoid hurting people you could foreseeably affect. And what was so revolutionary was that the manufacturer was held to owe a duty directly to the consumer, Mrs. Donahue, even though she didn't buy the drink herself and had absolutely no contract with them. So to zoom out for a second, where does negligence fit into the big picture? It's a part of tort law. You can think of tort law as the rule book for civil wrongs. It's all about the duties we owe each other to avoid causing harm, whether that's to a person, their stuff, or their reputation. For any negligence claim to have a shot, a claimant has to prove all four of these things. It's like a recipe. Miss one ingredient and the whole thing falls apart. For this explainer, we are laser focused on that first, absolutely essential ingredient, the duty of care. So, what is a duty of care, really? Well, at its heart, it's a legal obligation. It's the law stepping in and saying, hey, you have a responsibility to this other person to be careful so you don't hurt them. It connects the defendant to the claimant. Okay, so how do we even know if this duty exists? Well, there are two main ways the courts figure this out. The first one is the easy path. The situation is an established duty. Think doctor to patient or a driver to a pedestrian. The courts have seen these a million times and have said, yep, a duty exists. Easy. But what happens in new situations that the courts have never seen before? How do they decide then? For those new or novel situations, the courts needed a framework to help them make a decision. For a very long time, their go-to tool was a three-stage test that came out of the 1990 case of Caparo Industries plc v. Dickman. First up, foreseeability. The court asks a simple question. Was it reasonably foreseeable that what the defendant did or failed to do could cause this kind of harm to this claimant? And this is an objective test. It's not about what the defendant personally saw coming. It's about what a reasonable person in their shoes should have seen coming. Second, proximity. Now, this doesn't just mean physical closeness. It means there has to be a close enough relationship or connection between the two parties. Were they proximate enough in a legal sense for a duty to be fair? This could be because of a contract, a professional relationship, or some other direct link. And third, we have the big policy question. Is it fair, just, and reasonable to impose a duty of care here? This is where the court really takes a step back and looks at the bigger picture. Would imposing a duty here open the floodgates to thousands of lawsuits? Would it create an unfair burden? This is basically the law's safety valve. Now, this is super important, especially for your SQE1 prep. While that test is still vital to know, the UK Supreme Court has recently tweaked how we should use it. So the story doesn't quite end there. This quote right here from the 2018 Robinson case is key. What Lord Reed is saying is that when a new case comes along, the court shouldn't just jump straight into the Caparo test. Instead, their first step should be to look at existing law and see if there's a close comparison, a close analogy. They should develop the law bit by bit, incrementally, to keep things consistent. So, what's the big takeaway? The modern approach isn't about just applying the Caparo test like a rigid formula. It's about building on what's already there, step by step. Those three factors, foreseeability, proximity, and fairness, they're still super important, but they're used more as a guide, especially in those truly brand-new situations. All right, let's talk about a couple of tricky areas that love to pop up in exams. First one, omissions. Can you get in trouble for doing nothing? Well, the general rule of thumb in common law is no. You can, legally speaking, walk right past someone in trouble, and you haven't done anything wrong. But there are some major exceptions. A duty to actually do something can be imposed. For example, if a defendant has a high degree of control over the claimant, like a prison over a prisoner, or if they voluntarily taken on responsibility for someone's safety. Think of a lifeguard at a pool. And a really important one, if the defendant's own actions created the dangerous situation to begin with, you better believe they have a duty to try and fix it. And here's another exam problem area: liability for what a third party does. Generally, you don't owe a duty to stop a total stranger from hurting someone else. But, you guessed it, there are critical exceptions to this rule too. So a duty can pop up if there's a special relationship that gives the defendant some control. The classic case is Home Office v. Dorset Yacht. Basically, prison officers were supervising some young offenders, but they fell asleep. The kids escaped, stole a yacht, and crashed it. The court said the Home Office did owe a duty of care because its officers had control over the offenders. A duty can also exist if you create a source of danger that a third party then sets off, like, for example, leaving a construction site unlocked where you know it's likely that vandals could come in and cause trouble. All right, time for a quick knowledge check. In a negligence claim where it's a totally new situation with no clear precedents, what will the court consider in deciding whether a duty of care is owed? Is it A, just whether it's fair, just, and reasonable? B, just whether the parties have proximity? C, foreseeability, proximity, and whether it is fair, just, and reasonable? Or D, just whether the damage was foreseeable? Have a think. And the correct answer is C. In a truly novel case, the court will use all three of the Caparo factors, foreseeability, proximity, and fairness, as a comprehensive guide to decide if a new duty should be recognized, all as part of that slow, incremental development of the law. Okay, let's boil all of that down into a practical checklist for your exams. Here's your thought process. First, ask yourself, is there an established duty? If the answer is yes, fantastic, duty exists. If no, your next step is to look for the closest analogy in existing case law. If it's a truly new, novel scenario, then you turn to the three Caparo factors as your guide. And always, always be on the lookout for those special situations, omissions and acts of third parties. Don't forget those exceptions. So, there you have it. You now know how to establish a duty of care. That is a massive first step. But it's only step one. The next big question is, what standard of care was actually expected, and how on earth does a claimant prove the defendant fell below that standard and breached their duty? Well, we'll tackle exactly that in our next explainer.